salty brews, we're like, here we go. I'm the broken baker, chats coming in slow. Lawyers page, jury sits, the room hums alive. Leaning forward, screens glowing, this is where we fly. Screams on homebrew, chats the heartbeat, love and fear. Trials come and go, but we stay near. Crimes up, crimes down, you're always here. Drops, lawyer jumps, tension spikes, we freeze frame to the draw, shouting with dice, not mocking the mess, just sharing the rush, even the silence feels like a crush. Screams on roll, chats the heartbeat, loud and clear. Trials come and go, but we stay here. Crimes up, crimes down, you're always here. So grab your mug. Don't be late, the baker's life will set it straight.
Yeah, and we are sitting here waiting to be let in. So hopefully we will be let in at some point, and I can take this off. I think I have everything shared the way I'm supposed to share, so hopefully we will start soon. But I don't know. We'll have to wait and see. Oh, it's my pleasure. That's why you watch court cases with someone to talk over them, to make them a little more bearable. Been a day or two of not alive, but feels like a week. Well, Courtney, we're glad you're back. Hey, American Dreamer. There will be no such things. No such things. I don't know if you're tripping. AI boobies are double fakes. Why are you looking at AI boobies? It's at 2 p.m. Yeah, but they changed it and said the host has joined, so that's why I jumped onto it, Marissa. Marissa, I know, but calmale, woman. You paused a yeast-infected pregnancy to go live here. I love this channel so much. The drama lately has been too much, but here I always laugh my ass off. Well, Leslie, we are trying. What's happening today? They are arguing over phones that the Commonwealth has held in their possession for 500 and something days to all of a sudden think, hey, let's get a search warrant to see if there is any communications between Karen Reed and Aiden Turtleboy that will say there is a collusion between these two people, even though that they have had Aiden's phone for half a year longer than that. So they have all the communications between Karen Reed and Aiden Turtleboy. But nope, that's the one that's going to fix it. If they can just get to Karen's cell phones. Well, actually, they need to look at Karen's cell phones that they got from Karen in Karen's house to establish if it's actually Karen's phones. Seems like a fishing expedition. I'm not acting like they're late. I'm acting like I'm behind because I was 3 minutes behind the time I said I would start this stream because I had another stream. Well, he should be. Maybe he's going to tell you, Danny, that's exactly how you were made. Yes, Karen Reed's phones. Am I for or against Turtleboy? I don't understand the question. What is the question? Yes, always Always get rid on your phones on a military base. Yes, please do all the things. Thank you, Anime. But now those phones can't even get the latest iOS on it, but you have to fight for honor. It's just ridiculous that it's clearly a fishing expedition, and they're trying to, as I said yesterday when I read the motion to give it back to her, all of this is because the Commonwealth got egg on their face, and they're just mad that she was found not guilty, and now they're finding something that potentially could get them something on her, and it's ridiculous. Having the phones for 500 days, and then all of a sudden, oh, by the way, we want to look at the phones. It's that's I don't know. Hey, Colorado. And as you can see, I have moved a lot of the stuff. I still haven't shipped it because whenever I try to buy stamps, I have to go to the post office and talk to them tomorrow because it will not sell me stamps to either Canada or America. But I have packed everything up and I'm ready to go. So hopefully the post office can help me with this. Yeah, I don't get that. You have to be for or against someone. If you don't like people, you can still believe that the justice should be met. I don't get this. Let's all get on our team. Hey, Meredith O'Neill, thank you so much for joining up and hanging out with us. Because I know right now everyone is, oh, we have to be on team this or that. No, we don't. There's a case we have to cover. There's several cases in Massachusetts. All of them stem from the same thing: a bad prosecution. Oh, something's happening.
Number 8. Okay, welcome to all on Zoom. This is Courtroom 25 in Norfolk Superior Court. Please remain on mute. Thank you very much.
Folks, just check your cell phones, make sure the fans are off, please.
It's Amanda. Isn't it? Oh, Amanda's standing in for Emily.
Tell Aiden to mute his microphone.
We are ready
well,
to
I
just
don't know if he's. Can you hear it?
Oh gosh, I do not like that.
I hope I did it right.
Not here. Like these are made in Iowa.
Yeah, Judge
And there's
Corrupt.
another arraignment, Attorney Gavigan, with a Spanish interpreter in lockup. I'm not sure.
But I thought he wasn't supposed to be there today. But maybe he did.
That was a good move.
Oh, okay, thank you.
Yes, he's at home.
What is Mr. McBean's next date? Oh, no, when's his next date?
It's the 17th, and then I got an email from the ADA that she was hoping it could be put 12 to noon rather than 2.
We'll be on trial, so I can't.
All right, everyone, please.
Pick a different date.
Now looking to make a change, remind everyone, make sure your cell phones are off, right away.
Afternoon.
Afternoon?
We're going to start with number 8. This is Jermaine McBean, 25 CR 27. Mr. McBean is present along with his attorney, Paul Carlucci. Amanda Mullaney is standing in for Emily Farley. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Amanda Mulaney for Emily Farley.
Okay,
And good afternoon, Your Honor, Paul Carlucci on behalf of Mr. McBean.
okay, thank you for standing in. I heard this a couple days ago.
Sure.
I issued, bail conditions, and we need to, make sure Mr. McBean is in, agreement with those conditions and understands the consequences of violating them.
Mr. Bean, the court orders you to recognize in the sum of $500,000 cash with the following conditions. GPS.
Not $500,000 cash.
50,000, I'm sorry, 50,000, I read the surety, I apologize for that. $50,000 cash with the following conditions. That
doubt
you
you
undergo
read them.
GPS monitoring before release with home confinement, reside with your cousin at 65 Clifford Street in Hyde Park, Massachusetts, remain in Massachusetts, and stay away, and no contact, direct or indirect, with the victims. You assent to those conditions, sir?
Yes.
And you're hereby notified if you post this bail on a charge of the crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58. Your next date, which I hear might have an issue.
It's 10/17. It's scheduled for 2 o'clock, so I guess that's where it sits right now.
Okay. If there ends up being a problem with that, you'll let us know.
Right, I think there is a problem with 88 Farley, but we haven't resolved that yet.
Okay, we'll leave it on the 17th.
Your matter is continued to October 17th at 2 p.m. for trial assignment. You will be transported on that day if you haven't posted bail.
Thank you.
sir. Okay. May we take the return of the
Sure.
jury? Please approach sidebar.
Yeah.
It hasn't started yet. There's always the cases they had to go through before the ones we want to hear starts. This was just a guy who had his bail conditions and his bail set at $50,000. We don't know what, if any, what he had done. So there will be more people.
Next before the court, number 10, Commonwealth versus Evan Wilson, 25 CR 105. Mr. Wilson is present and represented by Attorney Robert Nelson. The Commonwealth is represented by Assistant District Attorney David Ominu. The matter is on for filing of motions. The parties could please identify themselves for the record.
Good afternoon, Your Honor. David Harmon for the Commonwealth.
Okay, Mr. Amanu.
Robert Nelson for Mr. Wilson.
Okay, Mr. Nelson. Has certificate of compliance been filed?
Yes, Your Honor.
Okay, great. And are there motions to be filed? All right, so we just need to set this up for a trial date?
We're actually going to ask for a lobby date if we could.
Okay, we can do that.
The second week in November, if we can.
Sure. They're looking for, go ahead, sorry.
That's okay.
Oh, I see, okay.
Is the 13th of November be available?
Okay, 13th of November for a lobby?
Mr. Wilson, your matter will be continued to November 13th at 2 p.m. for a lobby conference. Thank you.
Thank you.
Okay.
Oh, I just lost my next one.
Thank you, Your Honor. Thank you, Madam Clerk.
All right.
Thank you. Next before the court. Was, number 3, Commonwealth versus Antonio D'Souza, 23 CR 130. Mr. D'Souza is present and represented by Attorney Edward Swan. Commonwealth is represented by Assistant District Attorney Amanda Mulaney. Matter is on for filing of motions. If the parties could please identify themselves for the
Good
record.
afternoon again, Your Honor. Amanda Mulaney for the Commonwealth.
Okay,
Good afternoon, Your Honor. Attorney Edward Swan for Mr. D'Souza.
all right.
Yeah, free the phones and the dogs.
Do you want me to
Thank you,
take the
Stacy.
other motion?
Mr. Colonel, can I pass that?
Okay, so I have the motion to suppress statements. Have you seen this?
Yes, I was just
Attorney
given it.
Mulaney, you just given it. It looks like there probably needs to be an evidentiary hearing.
No, it's probably Marissa.
And
I bet it's Marissa.
how many witnesses do you think you'd need?
I would anticipate just one, Your Honor.
Just one?
Yes.
Okay. Half day, half morning, a 2-hour hearing?
I would anticipate calling Dr. O'Loughlin, and that could be maybe longer than might be a full morning or
Thank you, Sandra, for becoming a
a
member.
half day. I guess I have a hard time predicting where it might go.
Okay.
Mary did
Dr.
O'Neill and
O'Loughlin
Sandra on one day. That's
has
fantastic.
submitted something here. Let me just find it.
I think attachment 4 is his expert report.
Let me see that. So, my assumption is you would move the admission of the expert report subject to cross-examination. And, it would be relatively brief, direct, and then the Commonwealth would have an opportunity to question him about the report, presumably. Are you thinking of more than that for the evidentiary hearing?
I just hesitate to say it would be brief. I don't know exactly.
I'm just trying to understand how you would be,
Thank you, Shell, with
thinking
an S.
about,
Almost a whole baby. It's a
the
viable
hearing
baby
when
now.
it comes to Dr. O'Loughlin's testimony.
Yeah, so he, as Your Honor either has seen or already knows, he did a series of tests and evaluation, reviewed the video, audio of the examination, the interrogation, and would opine on all of that to the extent needed. I don't want to overstate it. I just didn't want to understate it and stand here before the court trying to squeeze more in than the time was allotted. So, I think you're right. It could be a fairly brief direct examination, half hour maybe.
Okay, all right, so, let's see if we can find a morning when we can do a couple-hour suppression motion.
We had discussed December 12th.
December 12th?
Yes, and I was trying to be mindful of the availability of
How would-
Dr. O'Loughlin.
How would December 12th be for an evidentiary hearing in the
Sometimes
morning?
I just don't catch
I'm
it.
looking it up right now.
Is it with a capital?
That is great.
Oh,
All right, you hit the jackpot.
Brianne.
All right, December 12th for an evidentiary hearing, okay? I would like to get any response to the motion from the Commonwealth in advance. So if you could file whatever you want to file by, doesn't need to be much in advance, but by the 9th or 10th, that would be great. Okay, thank you.
Your Honor, if I may, I filed 2 ex parte motions for funds, and that is supplemental funds for the work that Dr. O'Loughlin has done. I can explain if the court would like explanation or.
I will take a look at these when I get off the bench and act on them, and based on what you've given to me. Okay?
Yes?
Very good. Thank you.
Thank you.
Mr. D'Souza, your matter is continued to December 12th at 9 a.m. for hearing on your motion to suppress. An interpreter will be requested.
And I
Thank you.
apologize if I may just clarify the court. Mr. D'Souza does require a Portuguese interpreter for anything of substance to convey to him today. I will make use of Google Translate, give him that further date, and I have prepared him for what we have done so far, that it was not substantive.
All right, very good.
Thank you.
Thank you, Your Honor. Thank you, Madam Clerk.
Next before the court number 2, Commonwealth versus Jacob Shields, 2006 CR
Come on.
847. Mr. Shields is present, represented by Attorney Neil Madden. The Commonwealth is represented by Christopher Mead. I believe it's on a motion to seal. You
Yes.
could identify yourselves for the record?
Christopher Mead on behalf of the Commonwealth. Good afternoon, Your Honor.
Good afternoon.
Neil Madden, Mr. Shields.
Okay, Mr. Madden, I took a look at the motion to seal. Is there any opposition?
Your Honor, the Commonwealth would oppose the motion to seal on that it is under the test on a pawn, that there isn't sufficient, he hasn't shown sufficient cause. I understand it was a case, it was no pros back in, I think it was 2009. One of the things in the motion mentions that it was unfounded. In reviewing the no pros, the letter attached, I don't think that's, it said the Commonwealth did no pros the case, but it was because based on information that was provided by the Department of Children and Family
Yeah, I've been
relative to the
waiting for
victims
that.
at the time, and as far as whether, how the trial would, the effect, how it would be detrimental for them to go through that. That mentioned, and at the time, I believe Department of Children and Families had custody of the children, of the victims in the case. I understand the defendant has filed a motion, and does, make mention of, partially why he's seeking that, the motion to seal. I would say that there isn't, as far as, sufficient, cause, particularity of more information about the steps he's taken, since this case, as well as the steps he's taken
The
to
argument
try
is really
to,
bad.
get involved in the activities he mentioned in
Yeah.
his motion.
I was just about to say he sounds like Adam Lally. He can't finish
right.
the sentence.
I just suggest that this
Thank you
happens
so much,
today,
Michael Dodds.
it would be,
You are too
sealed
nice.
immediately.
I don't deserve anything.
Mr. Shields was, in a tough relationship with a woman that was 6 years older than him, had 2 boys. He took a sentence for 2 years because of, assault battery charge against her. He gets out early, he's at a halfway house, and these charges all come down on him. There's absolutely no basis for them. He adamantly denied them from the beginning. He's been living with this.
fine.
Now, even as I talk to him in the hallway, you can see he's been living with this, and it's been painful. He's moved on, his wife is here, the headhunter, Allison. He's now got his own business. They live in West Rochester. They have 2 young children. And he just wants to be able to go out in the community and coach and do other things and fill out quarry forms and, because these things hang around in his background.
Okay.
And,
All right, I'm going to take a look at PON again, and the standard, and, take it under advisement.
now,
Thank you,
if it's possible.
Yes,
I don't think the court can do it, but can you seal the Quincy ones too, since they were really part of this case? That's,
I don't think I can, seal, cases in another court.
yeah.
So if it was originally charged in Quincy and then brought here on an indictment, you'll have to go to Quincy to get it sealed.
That's what we'll
You
do.
might want to wait for an action by me on this, motion before you do it. Okay? Okay, very good.
Matter is taken under advisement. Thank you. Next before the court, number 11, Commonwealth versus Dwayne Anderson Jr., 25
on.
CR 128. The AAG might be out in the hallway.
Marissa, can you
It's so
share
crowded.
Microdots?
Attorney
Everyone
Gavigan,
follows
can
him
you-
already, but if
would you
there's
mind
one
calling them
person
in,
who comes
or-
in tomorrow and watch it, can you share his link?
It's for appointment of counsel also.
Okay.
Hearing of counsel. So Mr. Anderson is present. Duty Attorney Jim Gavigan is here, and along with Assistant Attorney General Alicia Willis. If you could all just identify yourselves for the record.
Holly Mac,
Good afternoon, Your Honor. Alicia Willis.
teaser, which kind
All
of
right.
sounds like teaser.
Attorney
in,
James Gavigan, I'm the duty
in
attorney
Danish.
today, Your Honor.
Okay, Mr. Gavigan.
Your Honor, Raymond Saig, I filed my motion as a result of the request by Mr. Anderson.
Okay, do we have that motion?
Look.
All right. Thank you.
Always 3 names for serial killers.
Okay, Mr. Saig, I'm going to allow your motion to withdraw and appoint Mr. Gavigan.
Thank you, Your Honor.
Teaser, which sounds like teaser,
Mr. Gavigan,
is a Danish.
have you had an opportunity to talk to
Nickname for it.
Attorney Willis about the case?
Yes, I have, Your Honor.
Okay, what do you think is the appropriate thing for us to next schedule?
Just a pretrial conference, Your Honor. I just want to review the material, speak to the defendant, Your Honor. And is my understanding that the defendant resides out of state in Ohio. And we're asking either that he can appear by Zoom on the next date or that his presence be waived, Your Honor, either or.
Okay, any problem with Mr. Anderson appearing by Zoom?
That's agreeable to the Commonwealth, Your Honor.
All
Thank
right,
you.
so we'll pick another date for a pretrial conference, and Mr. Anderson, you can appear by Zoom. All right, what date would you like?
December, an early December date that might be available to court, the 2nd or the 3rd or the 4th of December.
3rd?
We could try that, Your Honor. I have a trial the week before Thanksgiving that will most likely run into that week. If we could do December 10th, that would be easier on my schedule.
December 10th at 2 p.m., Your Honor.
Okay, great.
Thank you. And I'm sorry, we did try and confirm dates, but it was a little hectic earlier.
No problem.
So, Mr. Anderson, Attorney Saig has been allowed to withdraw. Attorney Jim Gavigan has been appointed to represent you. With this appointment, there is a legal counsel fee in the amount of $150. Your matter is continued to December 10th at 2 p.m. for a pretrial conference. You are able to Zoom if, Attorney Gavigan, if you just email me the day before, I can send you the Zoom
The link.
information. Yes, or it's the same one for this courtroom.
Okay.
Okay. Thank you, sir.
Thank you, Your Honor. Thank you, Madam Clerk.
Okay.
3 o'clock, she's tied up in the main till 3 p.m.
Okay, thank you so much for that. So, Mr. Gavigan, will you be able to help us on that arraignment and lockup? Thank you so much. Okay, we do have some probation matters we can do. Mr. Gavigan, you're ready?
Yes.
Or, sorry,
Come on.
Gavin Flanagan, sorry. This will be number 6. No, number 5. Commonwealth versus Vladimir Sylvain, 23 PT 32.
Yes, this is Judge Corrupt.
The parties could please come forward and identify themselves.
And
for the
we're
record.
going through all the cases until we
Good
get
afternoon, Your
to
Honor. Gavin
Henry.
Flanagan, probation.
Okay, Mr. Flanagan. Where's Mr. Sylvain? Mr. Sylvain, okay, good morning.
Good morning.
Afternoon, I guess, afternoon. So the violation here is a new case out of Stoughton, operating a motor vehicle with a suspended license.
Yes, Your Honor, and I did bring, it was on the 9th, that I did, hand you up, from the RMV on the 9th of that night. I guess there was fees that weren't paid. He did pay that night. The case was dismissed the next, the arraignment date.
Okay,
So just, and, he did take the initiative. He emailed me that night, everything that was on there, so.
Yeah,
All right,
that's weird if you have to pay a fee for.
I appreciate you bringing this to my attention. Is there any reason I shouldn't just dismiss the probation violation?
All the reason, Your Honor.
Okay, I'm going to dismiss the probation violation, and you'll be subject to continued probation on the same conditions. Okay?
Thank you, Your Honor.
Very good.
Some call it
So then the
TIS but that's more
violation is
Copenhagen.
dismissed, and you are discharged on probation with the same terms and conditions. Thank you, sir. Next, before the court, number 6, Commonwealth versus Michael Cote, 23 PT 122. Mr. Cote is present. Mr. Gavigan, are
It's
you helping
probably
us with
because
this?
it's a motion hearing.
Okay.
All of this is
Thank you.
just,
Or, it's just a motion to travel?
it's
Okay, with
just
probation officer
all
Kia
the
Brantley. Did I give you this or no?
in and out
Is there a
paperwork.
written motion?
Yes,
Slot
okay,
life,
Your Honor.
I will make you a muffin top.
Good afternoon,
anytime.
Your Honor. Kia Brantley for probation.
Okay,
Thank you.
let me just take a look. I have a written, handwritten request by Mr. Cote. How do you say, is that how you say your last name?
Cody.
Cody?
Yes, this is
Cody.
Zoom, so
Okay, bear with me
there
one
are no
second.
breaks in this. So we are just waiting for Aidens to come alive, or Karen's. So anyone we know here, Aidens here, AML, that's the trial channels here, Mark Betteros here, Roberta Glass, iPhone, I know that name. Where's old Grandy?
What does it mean to drop trailers? What is that, what do you do?
Well, I haul a lot of festival trailers to the festivals, drop them and leave, and then go get another one, bring it back. Usually about 3-4 trailers to a festival. And then I go get them when the festival is over, but
Roberta
it dries
Glass
up
is the
around
suck.
September. So I've been getting a lot of calls to do stuff out of state.
And how far how far do you have to go?
Sometimes I get calls to Alabama, Mississippi, Texas, Florida.
All right,
We're not making it a conspiracy. We're just saying this is how it goes. Oh, she's
you're
NPR.
currently under conditions that allow you to travel to New Hampshire, Maine, and Rhode Island for work, provided that you tell the probation officer the day before. Yeah, okay,
Oh, that's why. Thank you, Gail. I thought it was just someone who
Ms. Brantley,
wanted
is
to
there any
change
reason that I
counsel.
shouldn't allow Mr. Cody to travel more broadly?
No, Your Honor, Mr. Cody has
I think
been,
it's because
in
Karen's is a
compliance.
real hearing. This is
He
just-
fulfilled all his terms of probation. I have been his probation officer since his release in April of 2023. We did come before the court, I believe it was in 2023, in regards
Oh,
to
that's
the
middle.
traveling
I
within New
also-
England. He has complied with those. There hasn't been any issues.
I was thinking,
His-
I thought it was her,
The person
but
that
the A,
he hauls the trailers for has contacted me as well. to verify basically what
You should
Mr.
have seen me
Cody was saying
reconstructing
and
it.
their need. Apparently, he's very good at what he does, so he seems to be highly sought after. So probation doesn't have any objections, as long as he contacts me before he leaves and lets me know where he's going and when he comes back, he needs to
That
contact
sounds
me.
reasonable. All right, so I'm going to permit travel within the continental United States with prior notice to
Thank
probation
you,
on the
Slot
same,
Life, for gifting
on the same
memberships
type of
to
pre-notice. That is to
Watchdog,
say, you'll let
Gwen
probation
Schaefer,
officer know the day before,
Jim
let her know how long you'll be
Fairbrain,
gone. Okay?
Bain,
If you want
ADHD
to
in the
prepare
making,
new
and
conditions, I'm happy to sign
Jenna
them. What I'm going to
just
do is
returned
I'm going
a
to
couple days
endorse,
ago.
I don't think we've
Thank you
docketed
so
this
much.
letter request from Mr. Cody, but I think what I'll do is we'll docket it, and I'll endorse it as allowed, as we've described in open court, and I'll sign new
Maybe that's his
conditions
phone
for you.
number.
Yeah,
Call
sure.
it.
Okay.
Thank you.
Your motion is allowed. You remain on probation with all the other same terms and conditions.
Okay, thank you very much.
Good luck, sir.
Thank you.
Attorney Gaffney, have you heard from Attorney Angelatas? That's number 12, Calvin Cantave. Have you heard from Mr. Angelatas?
No, he was only appointed for arraignment only. He couldn't take it. It was
Oh.
continued to today to try and get him an attorney.
Yeah, that's
Okay.
why
So, Mr.
we
Gavigan,
always
we have
have like
another
3 or
case
4
for
easy
you.
cases.
Ms.
Today,
Burley?
there's just a
He
lot
is in
of them.
lockup,
So
Mr. Calvin
there's nothing new
Cantave.
to it.
Sorry, I didn't,
ADA. Sure.
They're just going through all
C-A-N-T-A-V-E.
the
I'll
easy
try to
cases
print out the
before we
docket
get
when I have a
to
moment.
the big one.
Do you want to give him any information
Oh, he
that you
didn't
can?
ask the judge this time?
Thank you. So second call on number 12.
Okay?
So we're still waiting on Attorney Bradel. We do have the plea on Mr. Bao that
Thank you, Microdots.
canceled, but
Thanks for
then
the
put
quality
back on the
ongoing
list.
coverage.
Oh, I didn't see it on the list, so it is
I like
definitely
it
going to
when you
go?
lie, but I
It's
do
a
my
Okay.
best.
error by our
Thank you for
office.
being here today.
All right.
So I printed out the docket. Do you want to do that?
And we have the
You're
arraignment
generous.
too.
We need to finish interpreting.
Oh, we need the interpreter for that, okay? Sure.
Okay, so,
Now I can
next before
almost
the court,
make it to the Halloween party.
Commonwealth versus Japheth Bao, 24 CR 199, a custody. Have you done a waiver?
Grand Stream Tide claims there's a
Oh, I'm sorry, okay.
fake victim
So
surprise
if you
hearing
could just
today,
identify
too.
yourselves for the record?
Good afternoon, Your Honor. Gordon McLeod for the Commonwealth.
I have good mods and they haven't
Good
seen
afternoon,
that.
Your Honor. Dan Mitchell on behalf of Jeff.
The kid is
Okay.
losing it.
Yeah.
Attorney Bradel is president on the other case.
Okay.
Baker, tell them to hurry
let me
up. I
see
have
at the
work to do.
sidebar.
Move. Get out the way. Get out the way. Dave has job to do. No, but it's hopefully, normally they have like 5 cases. What? Now they turned off the camera too. They don't normally do that when they go to sidebar. Everyone wave at Aiden. Hey, Aiden. The over-under on him being in his underwear. I would. I know Dave, when he is doing court from his treehouse, he is always naked from the waist down. He calls it Winnie the Pooh lawyering. I know he can't see me. It was a joke. We need something to do, and I can't do the reenactment again. How you can get pregnant to an air vent in a prison, because this is a classy crowd we have here now. It's not like the morning crew, Sue and others. Yeah, Bradel is in court. Mark Betterow is on the Zoom call. But again, it's not Aiden's case that's... oh, shit, that's the wrong one. It's not Aiden's case today. It is his case, but it's actually Karen Reed's case. It's the same thing when they did the sneak attack, not advising Karen Reed that they called Aiden in. It's just the opposite way now. So, yeah. I agree, Mass. I agree. Well, go back to right after I came back for lunch. I made a visual of how I believe he deposited his baby swimmers. Yeah, it's filed under his number, and it's the same stupid thing where they filed under Karen's number, but called Aiden during the trial. I still, I wish I could have seen Brennan's sphincter when they entered the courtroom. You could just see him tightening up so fast that he could turn a piece of coal into a diamond. Yeah, that's when they stormed the courtroom because they filed it under her number, but they didn't call her. And today, because it's her phones they want back, so it's related to Aiden's case. Yeah, do that. What? I'm sorry, Marissa has been day drinking. What? Hey, everyone. Apparently, Doink is streaming me. Let's everyone say hi to Doink. Hey, Doink. How you doing? You absolute lunatic. Stop smoking weed. It makes you paranoid. I'm trying to sit and explain things like he does it. So, oh, he cut me out. Son of a bitch. It's because he's good enough to use OBS. I can't do that. But did he cut out the bottom of it? Is he only showing the screen? Grant Smith Ellis. Yes, they should be in the courtroom. Marissa, has he cut the button, or can I put a... Oh, yeah, I can just do this. Sorry. Oh, he can... Hey, Doink. Grant, if you want the link, just hit me up on Twitter. I know you have me blocked, but I'm a nice guy. Even if I think that you are absolutely way, way, way too unserious to be doing this because you're way too stoned. I'll send you the link. It's no problem. Sharing is caring, but thank you so much. I hope, as a good boy, you did hit the like. You don't have to subscribe. I know you can't handle this quality content I have. Earlier this day, I made an explanation how, through an airbend with some saran wrap, you can make a baby. You should go back and watch that because your girl Lindsay and you, I'm not saying it, but she's not too old. There's still a few eggs left in that hen. So as soon as Frankie goes back to prison, get in there with the saran wrap and the turkey baster. I'm rooting for you, buddy. But if you're stream sniping, please hit the like because every like counts and we like to get out there. But Don't love you, buddy. You're too weird. But say hi to your crew. Well, my whiteboard is big enough when I do this. I had a bigger whiteboard before, but it's just too much. Doink is not a midget. Doink is... Oh, he muted me. Oh. Doink is the big clown. Dink was the small clown. Does this happen often? No, I haven't seen this before. That normally they'll just put on the annoying heart rate monitor and go to sidebar, but maybe they are showing some documents or it's a case that could be a little iffy. So that's why. You're trying the air vent thing with my upstairs neighbor. I hope it's consensual. Oh, are they crying? Broken Baker is likely talking. You should talk. Broken Baker's comments about you are unnecessary. He's a dick. Hey, it's not a dick if it's as small as mine. It's a penis. Thank you very, very much. How is am I getting on? Oh, he said get on, Baker. Oh, he took me down. Oh. Well, he's probably going to go to Melanie or... He's probably going to go to the Young Jerks. Oh, he took me down until the hearing resumes. That's too bad. Guess stream sniping, a better content creator, is one way to get more views. No, he won't get more views from it because no one goes to look at his channel. He's sitting with... How many? Can I see how many? No, Marissa has cut it, so I can't see how many people he has watching it. But I don't understand why he's writing in chat. Why doesn't he just talk? That's why we have microphones, so we don't have to sit here and say, "Hey, I'm so yeah." Oh, he did just show it. Yeah, at least. Hey, I got a DM from the trial channel. Do you have the code? Sorry, if I'd seen it earlier, I would have sent it to you, but I was switching channels and all that stuff. If you come ask me if I can help you, even though I think he's an absolute airhead, yeah, of course I'll help you, because being a nice guy doesn't cost me anything, because I don't lose viewers to Doink. Because no sane person watches his show. All the wonderful people are over here. So I wouldn't mind him sitting over there waving his arms and talking about conspiracies and how MK Ultra, the UFOs, and Martin Luther King is involved in all of this, and why Lindsay Gattani is actually being a secret agent for the FBI who's going to save everything, and Karen Reed is now going to attack Aiden, and oh. It's just a fake account. Oh. Oh. Damn. They're telling me to be nice. I won't be nice. Tell Brian he can clip my visuals. He is more than welcome to use it. And yet again, you spend 20 minutes giving him attention. Yeah, because I'm making fun. It's not like anything else is happening. I could sit and so yeah. Oh, is this the real Grant? I wish it was the real Grant. I hope it's the real Grant. Imagine if I was so lucky that I had Grant, but if he's in the courtroom, he can't hear me. Can he? No, it is the real Grant. Hey, Grant, you absolute airhead. I am so glad that you're here with us today. And you have to subscribe to my channel to write. Yes, I got you, brother. Unmute me on Twitch. Don't be a piss puss. We could have some fun. And Baker's entire country can't get into space. Why should my country get into space? We just sent astronauts into space. I don't know. Don't you do that in America? Just take one person, train him, and shoot him into space? I don't know. We did it with our guy. Oh, he has 48 viewers. Well, that's good for a guy who is going into space. Spaceman, spaceman, spaceman. At least be funny. Come on now. Say something. Don't compare us to Poland, because Poland is kind of like the Mexico of Europe. Be funny. Call me Swedish. That'll get my my temperatures rising. Feel my temperatures rising. And tell your mod to stop calling me a dick. That's not nice, Grandy. You should really have a better chat. You should tell them to be. See my chat, how well behaved. The only thing we do is call you Doink the Clown, but that's because of your big hair and you falling over the railings outside of the court. Smokes fake weed. Yeah, we're in space. Now what? I don't know. Take a piss. Yeah. Oh, I don't know. Yeah, I don't know. Poland is quite successful and don't have cartels. Well, it's probably still, I bet you I could still buy some cheap Polish cigarettes like back in the day. Well, because he's in law school, he absolutely haven't touched anything related to Lindsay's filings, because that would be him impersonating acting as a lawyer, which is illegal. It could get him in a lot of trouble. And his mom, who is a barred lawyer, absolutely hasn't done anything like that again, because Lindsay is pro se. If Grant or Wendy had touched any of that, they have to sign that they have touched any of that. And I know, because Grant is a man of honor, he has absolutely not done any of that. Lindsay woke up one morning and just out of the blue. Have you ever seen that girl who got the head injury and started speaking with that fake Chinese accent? Lindsay had the same epiphany. She just learned how to write kind of like a trial attorney. Grant had nothing to do with it, because if he did, he would be breaking the rules. And Grant is a very, very moral guy.
Second call
who will.
on Mr. Bauer.
Maybe
Next
Lindsay
for the court,
Gattani
numbers
is a double
4,
agent
7, and
working
9.
for Aiden.
Humboldt versus Aiden Carney,
Oh.
23 CR 313,
We up.
24 CR 43, 25 CR 88. If the Mr. Carney joins us via Zoom, if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Okay, Mr. Cosgrove?
Hello, Your Honor. Timothy Bradle from Mr. Carney. Good to be with you.
Okay.
Good afternoon, Your Honor. Attorney Steve Buzang on behalf of Ms. Reed.
All right, let's deal with Mr. Buzang's matter. I'm not sure that it's necessarily, well, I guess it's denominated 24SW0004, but it really is a request for setting a set of conditions for searching through Ms. Reed's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reed's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within the days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay.
Did you fuck up a timeline again? So he...
I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth having been in possession of the phone for an extended period of time has a finite amount of time in which it can seek authorization to search or to do the search. Let me just see for a second.
These phones must have been searched in the criminal case because they have tried and indict her before a grand jury before. Now Cosgrove is just fishing, so they must have it. But it's interesting if there was a deadline that he missed.
Yeah, so in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph, the search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized
Full
and
stop.
they haven't been searched.
No.
They haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the, attempting to break the logon information or the receipt of the passcodes.
Okay. Well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is the practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a
Marissa, can I
search
do that?
protocol. As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Move on.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no question that more than a year has passed and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right.
There was a ruling last
month. The case
month.
law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now, I've looked at the cases that Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, right. Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that results that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones, or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the boots trudge through mud, or blood, or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment and Article 14 of the Search and Seizure Law requires law enforcement to act diligently to obtain a search warrant without unreasonable delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's an independent, any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here, they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case. But I think it is relevant in terms of now they want to come back and look at her 2 phones, and they have all that evidence from Mr. Kearney. They have, I think,
all right, no, I understand those arguments, but I'm still trying to find a case, if you have one, that comes up in the context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
No, because there's no speedy trials, and he just said, yeah, well, there is a limitation that was set last month, but that's only in warrantless searches of phones. But they had a warrant on that one, and then you can keep it forever, even though...
You know what, I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the Fourth Amendment, I think again, this I don't think would have came up if we just let it stay and didn't ask for the 2 phones. It was only after I asked for the 2 phones that now this is somehow an ongoing investigation. When they've had the investigation was done, and there was nothing to it.
But she's not criminal.
If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But I think in terms of reasonableness and timeliness, Judge, I think, it's almost 2 years.
Okay, I'll take it under advisement.
Okay, and the matter, it does have a next date of December 5th.
Oh, you know what? I'm sorry, Margaret. I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
You know, I do, Judge. I don't think the Commonwealth, you know, in the preventive medicine case, the defense has some say in, you know, who would be a part of the tank team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you for the, with regard to the protocol that's proposed by the Commonwealth. That was part of the frustration that I had with the papers as they came to me.
Crossing over. I understand, Your Honor.
Yeah, so there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the two phones. I take it you can make a backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But before we get to that, Judge, could I just have a couple of weeks to provide some opposition to that? It'll be
opposition to what?
To the tank team part of the government's motion.
No. You can talk to Mr. Cosgrove. The two of you folks can talk and come together, come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay, not an elaborate briefing, but if I'm going to allow this, there's going to be a tank team protocol put in place. And I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before, okay? It's not all that complicated. So I'll give you 10 days to do that. If that gives you folks enough time to confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Is that enough time?
No, that's fine, Your Honor.
Okay.
Always happy to talk to Mr. Boothing.
All right. I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be, what are we? We're already October 8th. How about if you get it to me by the 21st, October 21st?
Good enough, Judge. Thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So both sides really need to be reasonable.
Understood.
Okay, 10:21.
Okay. We'll await your responses. You have until October 21st. And the matter's next on
Thank you,
December
Your Honor.
5th.
Thank you, Madam Clerk.
At 2 p.m. for hearing on the motions to dismiss. Thank you. I'll see you then.
Your Honor, may I be heard on the disqualification issue?
Mr. Bradel, in what docket did you file a motion for disqualification?
Judge, I believe that was filed in all three dockets. This one is styled as a in-ray search warrant docket. It's 20, I have it right here, just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10-6? I'm not going to hear you on that until I get a response.
Sure, I understand, Your Honor. It's just a little bit cart before the horse, I think, because counsel is forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not.
Until
I will not. I'll put you on for a hearing on a motion for disqualification. But I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure. I understand, Your Honor.
When would you like to schedule a hearing on that motion? Margaret, do you have? We could do December 5th, but let me, do you have the motion for disqualification? I have an affidavit.
Sorry, Judge, there's an impounded and a redacted one. The redacted is for the public docket, and there should be an unimpounded one, or unredacted one, rather. That's for the court. And I believe they were filed in all three of those dockets. The 24 and the the 23 case for Mr. Carney and this in-ray search warrant case. And if not, I'll just make sure Madam Clerk has them in this case, but
I think they might be downstairs, because I didn't think it was in your
Sure.
files today, and the files are so voluminous.
Okay. What's the status of the 2025 case?
the,
25, CR 88.
that's had a little bit of a back burner, Judge. I think there's a pretrial, where it's in the pretrial phase right now in terms of, discovery.
All right, but there's no disqualification motion filed in that one.
Correct, Your Honor.
Okay?
Correct. The 24 case on the part of Mr. Carney, Mr. Cosgrove acknowledged, and withdrew. The 23 case we contend
I'm
is... Sorry.
Say that again?
Sure. The 24 case on the part of Mr. Carney, that's 24-0043.
Yeah.
Mr. Cosgrove has acknowledged and withdrawn from that case, and I believe he's got a couple more weeks to confer with the district attorney and provide some sort of a replacement. The 23 case, we have now moved to disqualify him as for the same exact reasons why that apply in the 24 case, in the sense that Ms. Gattani is suing him and is also a key witness in the 23 case by the government's own admissions. The detective on the case swore to it.
That's fine. So you haven't filed a motion to withdraw on the 2025 case?
Correct.
Okay, so we'll take up the 2020. We'll put all the cases on when it's an appropriate time to do a hearing.
Sure.
So when would you like to do the hearing?
Judge, could we do it a little before December 5th, in November at some point? And if we can't get a date right this second, can we report?
Oh, you can get a date right this second? Okay. We'll figure it out.
Sure.
December looks better to me than November, Your Honor, and part of the problem I have is that in moving to disqualify me, particularly since Mr. Bradel has, or Mr. Kearney has moved as well to disqualify the Norfolk County District Attorney's Office, is who should respond to the motion to disqualify me? Should I respond?
They are already
Should or can the
disqualified.
Norfolk District Attorney's Office respond, or should it be the Attorney General or someone else? So there are discussions underway as to who the appropriate person is to respond to that, and I expect it will take a little bit of time to hash that out.
Okay. We have a hearing date, December 5th?
We do, Your Honor.
All right. It should be here. Yeah. What? No.
I will move it.
Yes, it should be in this session, December 5th.
Very good.
Okay? And that's at 2 o'clock?
Yeah.
Okay?
Thank you.
So, Mr. Carney, your matter is continued to December 5th for a hearing on the motion to dismiss and the motion to disqualify at 2 p.m. Thank you.
Thank you.
Thank you, Your Honor.
Okay.
May we have Mr. Cantave?
What a load of utter bullshit. What a load of bullshit. That this judge has never ever made a decision. It's so annoying. Let's just keep dragging. Let's give Cosgrove a little more. And why is Cosgrove asking if the DA's office should respond? They are conflicted out. They've been conflicted out. That's why he's in as a special prosecutor. So they can't respond. There should be watertight bulkheads between Cosgrove and the DA's office. They shouldn't respond to anything. He's working because they can't work, or else Lally should be working, or whoever. This is absolutely ridiculous. Again, this is why everyone had a fun weekend. Everyone was making fun of each other. Everyone was attacking each other on the twit. But this is what's important. This is how Massachusetts run their justice system. It's the double sue birds to people. Well, we don't care. Yeah, I'll come back again in 2 months, and maybe I'll make a decision back at that point. When did you file these motions? Why don't you read your own docket? It's amateur hour. It's amateur hour. How the hell can they keep on pushing everything down the hill? I really don't understand it. It's just stupid. They better not ruin him and Karen Reed's Christmas this year. They will, because at the next hearing, Cosgrove will. I don't know. They already downloaded that phone. I am 100% sure of that. Cosgrove doesn't know what he's talking about. And his motion that Tully had to go through Karen Reed's phones to certify that it was Karen Reed's phone, even though they were taken from Karen Reed. Absolutely ridiculous. Colorado Mountain Girl, thank you so much for the 10 corner kisses over on Buy Me a Coffee. And Marissa, thank you for would rather pay me. You didn't have to pay me. I hope Grant's chat paid him a little bit for the great work Marissa and my mods are doing for getting all of these links to me and calling the courthouse when we need it. Please say thank you sometimes to the mods, because I'm just the pretty face and I ain't that pretty. Why is Karen Reed in court again? Thought she got off. This is because Cosgrove is doing a 2025 investigation into the collusion to harass witnesses between Karen Reed and Aidan Carney. They already tried to get a grand jury to indict them, and the grand jury said, no, ain't gonna happen. So now he's going grand jury shopping, which means he's just gonna invent, oh, we're gonna do this, and then we're gonna try another grand jury, and then we're gonna try another grand jury until something, because we need blood after the failure it was to have lost twice against Karen Reed. The problem in this argument is, to have a conspiracy, you have to have two people at least. And what's going on here is you have Karen Reed, Turtleboy, and Natalie the German. They claim that Karen sent stuff to Natalie the German, and Natalie the German then sent it to Turtleboy. We know that circle happened. Nothing here. But now they are claiming that they need to look at Karen's phone to find evidence of her making Turtleboy harass witnesses. They already have Turtleboy's phone. Anything that's not on Turtleboy's phone, because Karen Reed could be sitting over here and writing page up and page down about, go out to Jen McCabe and tell her she looks like a horse. Go out to Brian Albert and say, you couldn't even get laid with Brian Higgins. Go out to Coco and said, did Brian really rock your world, or were you lying? Go out to Kerry Roberts and say, do you still flick the bean to the memory of John O'Keefe because you couldn't have him? All of that could have been on Karen's phone. But as long as it hasn't made this journey or this journey, so it's not on Turtleboy's phone, there can be no collusion. Because thoughts, you can't put taxes on thoughts, as we say in Denmark, even though we are a socialist country and they will try at some point. You are allowed to think and write down as long as you don't act on it. As long as Karen didn't send it to Aidan and say, hey, go out and do this. There is no collusion. So why do they want Karen's phone? Because they already have Aiden's and they downloaded Aiden's. This is a fishing expedition to try and find something. Because they are butthurt that Karen beat them in the criminal case. They're trying. Sadly, in Massachusetts, there ain't no law. That's why it's important we don't waste all our time trying to sit and attack each other in everyone else's chats, but instead that we spend a little more time to try and help out, raise awareness, and support the people who are hit by the No Justice Massachusetts. Thank you, Kelly, for thanking the mods. And thank you, Zach, for not supporting the channel. And thank you for supporting Grant. Don't they need evidence before they charge someone? I'm so freaking confused. Well, they are investigating a possible conspiracy between them to have witness intimidation. They already tried to get a grand jury to charge them. And the grand jury said, no, you don't have enough. And now, all of a sudden, when Karen said, hey, I really want my phones back, they thought, oh my effing God, we didn't look enough on those phones because they don't want to give them back. Why? I don't know. And that's the really weird part about this. Why don't they want to give Karen's phones back? There is nothing on hers that could implicate, unless they have an idea that Aiden has deleted a ton of stuff. And they can prove he deleted it, and they need her phone to get it back. Yeah, as Lucy said, they didn't find it Aiden's, so unless they believe, and we know there will be artifacts on the phone showing if you deleted something, but they most likely didn't find any of that either. So there's no reason to do this. Grant is good, Grant is great. All hail Grant. Thank you, Zach. Love the support for Grant. He doesn't get it in his own chat because they're assholes. Still a towel trolling. Keep up the good work. I will towel troll as much as I can. But thank you, Grant, for visiting. And hopefully you will learn a little bit about how to do it in the future. Because these cool people who hang out over here is not assholes and call people dicks like you do. Well, Sue does, but Sue is special. Aiden is on trial for what? The 2023 is witness intimidation. The 2024 is the Lindsay Gattani. That's Lindsay Gattani. 2025 is not on trial, but is an investigation into possibly colluding with Karen Breed to commit witness intimidation. So there are three different dockets on him. So yeah. The phones often keep records of who did what, when. If they did anything criminal, they are not going to want to give the phone up. But these are not the phones that, if anything has been deleted, the GPS that a lot of people talked about had been deleted from her phones. Those phones have been given back. She had 4 phones seized. The first 2 from the first trial has been returned to her. The last 2 is only related to what she communicated with Aiden, Natalie, the German, whoever. So the looking for nudes phones, they have been returned. They were returned with her car. These are the 2 other phones that was taken in 2024. Only to prove that she and Aiden colluded to have Jen McCabe called a horse face, to have people yell at Chris Albert that his chicken palm is mediocre, have people tell Colin that he looks like Vanilla Ice trying to be tough, all of those horrible witness intimidations that went on, that's what they're trying to find evidence of. But they already have the receiving end. And unless they can see, well, there's a shit ton deleted, just like on Jen McCabe's phone, you can't really, there's no reason to have Karen's phones. I give Grant a little credit for taking a joke. He didn't even take my wrench when I said his mom drank too much Tylenol. Well, he was really mean. He yelled at me for not going into space. I don't know why that's a thing, but hey, maybe it's because he's so high. I can just buy a Lexus because a Lexus can fly off into space. Oh, 2020, no, 2025, that's witness intimidation. Is that? Yes, I can't figure out half of this. It's so annoying. The phones that Aiden and Karen were talking on Signal. Apparently, according to what we read yesterday, Natalie German took pictures of stuff that was sent on Signal. If it's on Signal, they can't decrypt it. They can't find it unless it's saved in screenshots. But they have Natalie the Germans. They have Aiden's. So they have 2 out of the 3 prongs in the triangle. And if those 2 corners doesn't give anything, what's the last corner going to give them? It makes no sense. But hey, it's Massachusetts, baby, where law comes second and whatever else we want comes first. Everyone here, Albert's raised 911 call. Yes, where he cried and said, "Oh, I'm being harassed because someone was standing outside." That's why it was so fun that Krusty O Panties was putting up a sign today about they are real men. They're not like Aiden crying online. Bitch, you like people who hit people with cars, and then goes into politics, call people up and harass them. Maybe I'm just gonna. I'm not sure if Grant is still here, but I'm gonna say it. Keep it between us. I think Krusty Panties is a bad person. Yes, I went that far. I'm just gonna say it. Krusty O Panties might not be a good person. I know it's hard to hear, but that's where I'm going right now because she's continuously wrong in everything. Yesterday, she started hating on Kelsey Fitzsimmons, and we know it has nothing to do with Kelsey Fitzsimmons' trial. It has everything to do with Kelsey Fitzsimmons being supported by the same people who supported Karen Reed, because she is, I believe, the technical medical word for it is a thunder cunt. I could be wrong, but I believe that's the English word. My English isn't that good. So I'm just going to go out there and say, I think that's the word for what she is. I don't have anything to hide on my phones either, but I'm still one of those, where's your warrant people? That's the Norfolk County syndrome, Massachusetts syndrome at this point. Whole place is cooked. Yeah, again, if you ever watch trials, if you might have gotten into trial watching during the Karen Reed trial, there's always one golden rule you will hear on every channel covering trials. Shut the fuck up. Police are not your friends. The only words you say is, I want my lawyer present. Other than that, you are obligated to give them your name, I believe. In Denmark, you have to give them your name and your date of birth. That's the only things that they can get from you. I don't know what rules there is in America, but other than that, your only words are, I would like my solicitor present, if you please, my dear sir. Well, we can fix this. I'm here to help you. I would really, really like a lawyer present. And you don't go on TV and give interviews, Karen Reed. Does Krusty need to go outside and touch some grass? I don't think that'll help, and I will feel sorry for the grass. She doesn't look like she bathed much. You have to provide identification. You only no in Denmark. You just have to give your name and our social security number is our date of birth plus 4 unique numbers at the end. You have to give them that. Other than that, you're not required to give them anything. Well, if you're being stopped in a car, of course you have to show them your driver's license. But if I was peeing on the street and they stopped me and give me, I think that's $100 fine. And I said, I don't want to give you my name. That's illegal. That's resisting arrest or resisting. And I would then be fined for that too. So, yeah. To help you get to space. Thank you, Stringer Bell. I'm still, it's way too late to get the tickets, but it could have been fun if I knew that Aiden was doing the Halloween thing to fly over and be. I've never been to a Halloween party because we don't like Satan, so we don't celebrate all those pagan parties. Yeah, no Dateline, no 2020. Do all of those when you're not guilty. Boom. Then you can go on every one of them. But Post is on strike. That might be some of your issues. Could be, but I have a problem. It's because there's a new rule because of all the new taxation laws that anything under $800 can't be shipped to America unless it's a gift. All of mine are gifts. But when I go to the website, for the longest time, it was just you have to wait, return. That's like 3 weeks. Now it'll just give me wrong zip code on everything. So tomorrow I'll go to the post office and I have 1, 2, 3, 4, 5, 6, 7, 8, 9. I think there's 2 names I forgot or can't find the address for. But look, they come with stickers. A little Molly sticker. This one is to Yo-Yo. All the way off in, luckily you can't see it. But yeah, that's a lot of things going out as soon as everything clears and I can get it shipped to you. After my last move, I only have 3 phones in my house. But I think I have 5 tablets. One of them is my dad's tablet that I couldn't open because I couldn't remember his code when he died, and I didn't want to go to iPad and try and figure it out. That's stupid. Is the US government still shut down? Yes. But everyone, thank you so much for following the Aiden Karen hearing today. We are going to go back down to Florida to figure out how you get pregnant with a man you didn't have sex with. Maybe along the way, we'll also figure out if she unalived her boyfriend. To me, the most interesting part is still how do you get babies without having sex? I thought only Mother Mary could do that, or what's her name? But apparently you can do that in Florida as well. Thank you all so much. Go follow Microdots. Do all the YouTube things that you hate us talking about. And I need a little toilet break, and then we'll be back in Florida. So hang out, talk to each other, and tell Zach that he should stop harassing Grant, because Grant might be a clown, but he's our clown.